Welcome to our second 3CL seminar on corporate reorganization, law and forces of change. Today our speaker is Professor Sarah Paterson. She is Professor of Law at the London School of Economics and Political Science, where she teaches and researches corporate insolvency and restructuring laws. Before joining the LSE, Sarah was a partner in the restructuring insolvency group of Slaughter and May, with whom she retains a senior consultancy. Sarah publishes widely in the field of corporate insolvency and restructuring law, including her recent monograph, Corporate Reorganization Law and Forces of Change, published with OUP in 2020, and she will present on the basis of her book today. She's a former president of the Insolvency Lawyers Association, a member of the Council and the Technical Committee of the ILA, and a member of the General Technical Committee of R3. Sarah, it's such a great pleasure to have you here today. Thank you for coming up to Cambridge. It has been a pleasure kind of chatting with you before we start this seminar. Thanks for everyone for your interest joining us today. As usual, we'll have a presentation first and then an opportunity for exchange and discussion, and we aim to close by 5 to 2. Sarah, the floor is yours, and thank you so much for being with us today.
Thank you, Felix. Thanks for such a warm introduction. I cannot tell you what a joy it is to be here in person rather than over Zoom. So I'm delighted to see you all. And thank you for coming. I know how busy term is, it's really great to see you. So, as Felix says, I'm going to talk about my monograph, published at the end of 2020, yet to have a formal book launch due to the circumstances. So this is part of its journey to getting out into the world. So I'm going to sort of start with the motivation for the book. And I know that I think some of you might be doing the corporate insolvency course, and I don't know how far you have got yet with the theoretical framing, so the arguments about what we think corporate insolvency law is really there to do. But in 2014, the American Bankruptcy Institute Commission came out with a really extraordinary report into Chapter 11 in the US. It's a really extensive report. I don't know whether you have looked at it at all in your classes. And the Loan Syndication Trades Association, which is the trade body in the US responsible for the syndicated loan market, came out with a fairly furious response to lots of aspects of the ABI Commission report. But what really interested me was that their debate was framed in very similar terms to the debate in the 1980s between scholars adopting what I'm going to call an economic approach, so an economic approach to what they think corporate bankruptcy law should do, and scholars adopting what I'm going to call a progressive approach, and I'll justify that a little bit as I go. And the ABI Commission LSTA debate looked very like that 1980s economic versus progressive debate. And yet it seems to me that that 1980s debate was very much a product of the way that companies were organized, financed, and the actors in that game that existed in the 1980s. And so the quote on the slide comes from Thomas Jackson when he was really looking back on his work in this area. And he said that in a way the debate was framed, or it was a product of the firms, the capital structures, and the players that existed when the debate kicked off. And yet it also seemed to me that some very significant forces of change from fields proximate to corporate insolvency, so by this I mean the finance market, the corporate market, have dramatically changed the landscape. The way that you restructure companies now is fundamentally different from the way we restructured them in the 1990s. And as a result, lots of different types of cases have emerged for large corporates. And I should say the book is only concerned with large corporates. The debates for SMEs and for micro companies are quite different from the debate I engage in the book. So this is a large corporate thesis. And what we've actually seen is quite a different approach to these different types of cases in the US and England. So that was the issue I really wanted to look at. And the controlling argument in the book is that if you use, and I'm going to say it's a conceptual framework, I'll explain that in a moment, but if you use a conceptual framework which was developed in a very different context, so when companies were organized and financed in a particular way, when the players in the finance market were quite different, if you use that conceptual framework to analyze modern adaptations, then you risk taking quite serious wrong turns. And the book is comparative, I have been fascinated over the very long run of my career by the differences between the US and the UK, so both convergence but also difference. And US Chapter 11 is very much rooted in full financial and operational reorganizations. So the sort of the founding idea of Chapter 11 in the 1970s is that you use it to reorganize all of the liabilities of the firm, the financial liabilities and the liabilities owed to operating creditors. For reasons I'll explain, certainly since 2008, a significant number of large corporate reorganizations have only involved financial creditors. You don't go anywhere near the trade. You leave the trade alone. And I argue in the book that the US has struggled to adapt to those sorts of reorganizations, adapt its theoretical framework to those sorts of reorganizations. In part, I suggest, because it continues to try to apply the conceptual framework developed for full financial and operational reorganizations to these much more limited reorganizations. On the other hand, I argue that England's done rather well, that we have done quite a good job of thinking about reorganizations that are limited to only financial reorganizations. But I don't end there. I suggest that change is on the horizon, and that those changes may actually see a return to full financial and operational reorganizations, at which point England may need to adapt, and it may struggle, and that there are potentially entirely new adaptations as a result of some much more dramatic forces of change that are going on at the moment, which will demand flexibility in both jurisdictions. So this is a very busy slide, and I think that Felix will make the slides available afterwards. This will hopefully have some use after the event, but it's a very busy slide. But I've tried here to unpick what the concepts are and how I use them in the book. So this slide is about how certain concepts became very entrenched in the debate between the economic scholars and the progressive scholars in the US, but why they were much less salient in England. So the first concept is the idea of unsecured creditor protection. And scholars viewing corporate reorganization law through an economic lens in the US tend to be very skeptical about attempting to steer the case so that unsecured creditors do particularly well. They take a much more market-based approach. We don't really have time to go into that here, but I can add to that in the Q&A. On the other hand, for scholars using a much more progressive lens, protecting weakly adjusting unsecured creditors is a crucial job of corporate bankruptcy law. So making sure that consumers and employees and small trade suppliers are looked after in the corporate bankruptcy case, that for them is fundamental. And so there's a real clash. In England, this never really becomes a significant issue because for most of the time when these scholars are writing in the US, we are using something called the London approach to guide rescue of large companies. So these were a set of social norms that the large banks complied with in thinking about how to reorganize financial creditors. And it was fundamental to the London approach that you limited the reorganization to the financial creditors. So in England, through the 1980s and the 1990s, we do not think it is a good idea to compromise trade because that will destabilize the business. It makes it harder for the business to recover on the other side because your suppliers have lost confidence in you and so on. Much better to leave your suppliers alone, to leave your trade creditors alone, and to try to keep the negotiation between the financial creditors. So this idea about whether you should be tilting towards an outcome that protects the unsecured, by which the debate in the US really means weakly adjusting unsecureds, never really gets going in England. It just isn't really a feature of the debate. Second concept that's very important in the US debate is the problem of collective action. And here, unusually, both economic and progressive scholars tend to agree. There's broad agreement on the role of corporate reorganization law in preventing creditors from rushing in and grabbing the assets. If they're able to do that, then the business will fall apart. And even if a rescue is the most value maximizing option, it won't be able to emerge. And so economic and progressive scholars actually agree on the role of corporate reorganization law in solving that collective action problem. And that's the dominant idea of a stay or a moratorium, which bankruptcy law provides you with. Again, in England, we just don't really worry about this at all Because we have the London approach social norms, and a fundamental idea of the London approach was that you cooperate together to see if you can save the borrower. So we don't need a legally mandated moratorium or stay. We have this entrenched idea of cooperation in a landscape that's really social norms rather than law. And so again, this idea that is so foundational in the US literature, not tremendously important in England at the time. Third concept in the book is secured creditor control. So scholars adopting an economic lens, perhaps unsurprisingly, put a high premium on respect for secured creditor control rights. If security provides them with those control rights, they should be able to exercise them. If they can't, then that may have a chilling effect on the availability or the cost of finance for healthy companies in the economy. That's the basic pitch. Progressive scholars, on the other hand, worry a great deal that secured creditors have an incentive to prefer a sale, provided that will generate enough to repay the secured loan. In other words, they have a liquidation bias, and that may prevent a rescue transaction, which might be better for small suppliers because they can go on trading with the business. It might be better for employees because it maximizes the chances that they will keep their jobs. It may be better for the community because it makes it more likely that the business will stay embedded in the community in which it currently operates, with all of the benefits for the community that generates. Very skeptical that secured creditor control is a good thing. A major concern that it will undermine those benefits. And so progressive scholars tend to want to see bargaining power shifted towards the debtor company, so away from the secured creditor and towards the debtor. With an eye on the time, I won't go into the English approach in too much detail, but suffice it to say that we have a very long-run history going all the way back to the 19th century with what an American would call the blanket lien. So finance creditors having security over all or substantially all of the company's assets. And we've been much less anxious about that and have tended to associate it much less with having a liquidation bias. The flip side of secured creditor control, the fourth concept, is debtor control. And here we're really just flipping the argument. Economic scholars very skeptical about debtor control rights, a concern that that will just lead to the company holding the creditors at bay and running down all the value in the business. So the classic example is Eastern Airlines, where it is alleged that the very colourful owner of Eastern Airlines goes into Chapter 11, uses that to keep the creditors at bay, flies the planes all around the world, accruing all sorts of liabilities, and by the time the creditors can get in, whatever value is left in the business has gone. On the other hand, progressive scholars endorse debtor control rights because they think it is more likely to promote a reorganization objective. Firstly, because if the debtor can control the case, they are incentivized to file early, and all insolvency lawyers will tell you that the earlier you file, the greater the prospects of success. Secondly, because a reorganization is more likely to preserve the directors' jobs, so that's more likely to be the transaction which they want to see emerge. And finally, because they have the knowledge of the business and of the suppliers and so on. On the other hand, in England, this is an out-of-court procedure conducted solely amongst the financial creditors using the London approach norms. The debtor is very much there. The idea of debtor in possession isn't foreign to English corporate insolvency and restructuring lawyers. We just did it in a different way. And in the book, and again, we don't have time to look at this today, but in the book I also say that one of the reasons debtor control does not become so significant in England is because we have a very different experience of deregulation, mass tort and class action litigation cases than the US. Fifth important concept in the US debate is bargaining and litigation. So economically minded scholars tend to be very concerned with the very complex approach to valuation in Chapter 11. So Chapter 11 has an extraordinarily complex approach to valuation, to valuing the firm and deciding who should get value and who shouldn't. On the other hand, progressive scholars are quite a fan of this more complex valuation. And here I'm generalizing terribly, but at a very general level, they are much happier with this complex valuation idea because they believe that it is more likely to promote higher valuations and that is more likely to promote a return for those at the bottom including the constituencies they are most concerned about, the weakly adjusting, unsecured creditor, supplier, consumer, and so on. On the other hand, in England, we just do this completely differently during this period. So the norms in the London approach are initially enforced by the Bank of England, initially as regulator, and then subsequently just because of a very deferential relationship between the big British banks and the Bank of England. So all sorts of apocryphal stories that or potentially apocryphal stories that if you behaved badly, you were summoned round to the Bank of England and given a cup of tea in a nice china cup. Somebody said, listen, I hear you're not quite playing by the rules here. I'm sure that can't be right. And then after your dressing down at Threadneedle Street, you went back to the bank and said, gosh, we better get with the programme here. And for those of you doing corporate finance, that finds its way into the metaphor of the governor's eyebrows. Literally all he had to do was raise his eyebrows for you to fall into line. So we are a very long way away from an idea of a complex mechanic in law motivating bargaining. We are just doing this in a completely different way. And even when that relationship with the Bank of England begins to fade, when the Bank of England adopts a much more monetarist approach to the role of a central bank, and the relationship between banks and the Bank of England changes quite dramatically, the London approach doesn't lose its force overnight, because at this point, banks are still the primary lenders in both the primary market and in distress. And the concern is that if you don't behave by the rules of the game in the reorganization, you will be frozen out of the primary syndication market. In other words, the next time one of the banks around the table is trying to put a syndicate together for a new loan, they will say, actually, you're not welcome at this table, because when XYZ borrower was in trouble, you did not play by the rules of the game. And so you recognize there again, if you're doing other courses outside corporate finance and corporate insolvency, you'll recognize the idea of something which operates by social norms, working because we've got a small market with shared values, but which is able to enforce those norms by excluding somebody who doesn't play by them. We see it in insolvency all the time, actually. There's some fascinating literature about debtors' prisons in the 19th century, and the ability for some of the debtors to freeze out other debtors from best access to the right parts of the prison if they didn't play by the rules of the community. But it is so fundamentally different from the way that Chapter 11 is operating, and so we just don't have the same conceptual framework at all. And then finally, transparency and disclosure. Broad agreement on the vital role of disclosure in the US. We have a long-run skepticism of disclosure in insolvency in the UK. So it was fundamental that the London approach was confidential. One of its major benefits was seen to be that it could take place behind closed doors in the debtors, normally the debtors' lawyer's office. I remember doing London approach negotiations, complete with lots of pizza, lots of Coca-Cola, and in these days lots of smoke, because it was before the smoking ban. And you hunkered down to do the deal, and it was absolutely fundamental that it was confidential, that you were keeping the trade happy and comfortable, and you were trying to keep a business as usual message as much as you could by keeping the negotiations between the financial creditors. So this idea of transparency and disclosure, very, very different approach to it in England. And so then the next important move in the book, and this might be as far as we get today, the next important move in the book is to look at what I identify as 6 forces of change and what the consequences of these forces of change are, I argue, for the concepts, so for those foundational concepts. And the argument in the book is that these forces of change require us either to replace some of the concepts that are seen as so fundamental in the US, or at the very least to reformulate them in a different way. And that this poses more of a challenge for US scholars because they are wedded to the original concepts, and less of a challenge perhaps for English scholars because those concepts have never had so much salience in the way that we think about reorganization. So the first force of change is the rise of leverage. So it is, and the book charts each of these forces of change. So actually, even if you have no interest in insolvency at all, each chapter has a sort of small historical account of how these forces of change have emerged in finance and corporate markets, which I hope are of much more general interest. And the first of these is the rise of leverage. So companies being willing to borrow much more relative to their earnings than they would have done in the 1980s. The consequence of that is that it is now materially more likely that the only liabilities you will be seeking to restructure are your financial liabilities. Even in a US restructuring, so we see big US law firms really playing around with Chapter 11 to find ways of doing rapid cases that only restructure the financial liabilities whilst leaving the trade alone. Because the big problem you've got is that you've borrowed too much money. And so the debt service costs are very high, or perhaps you've got a looming maturity in a slightly tighter debt markets. So you're not going to be able to refinance at the same level. In either case, what you want to do is you want to deleverage, but deleverage in your financial debt, whilst not scaring the horses with your trade. And so I argue here that this means that unsecured creditor protection is much less important, even if you are a progressive scholar, because now the unsecureds in the case are probably hedge funds and credit funds, and they are not trade suppliers or employees. These cases are limited to financial debt, and our unsecured junior creditor is now a strongly adjusting, fully informed party who invested in the junior debt quite deliberately to get a higher interest rate. You know, it was a quite deliberate investment choice. And now, in a sense, that risk has come home to roost because the business has got an unsustainable level of debt. But even if we're a progressive scholar, I argue that we should think about that quite differently, and that both economic and progressive scholars ought to be able to coalesce around the idea that what you want to do in these cases is reduce transaction costs. You want to be able to delever quickly at as low cost as you possibly can, so that you can emerge with a sustainable level of debt and the business can trade on. And so we think of transaction cost theory as being a theory that is particularly attractive for scholars adopting an economic lens. But in the book, I argue that here, whether you're adopting an economic lens or a progressive lens, actually you should worry about transaction costs. Secondly, the rise of trading. This was a dramatic change in my 20 years in practice, the rise of the market for distressed debt. So when I first started out, if a business ran into trouble, the bank had the choice of trying to restructure its liabilities, so reduce its interest rate, increase its maturity, or perhaps do a debt for equity swap. If that didn't work, you sold the assets, but those really were the options. Now a third vitally important option has entered the equation, which is you can sell to somebody else. And in a large case, the big distressed debt funds, if they think a restructuring is in prospect, they will be there to buy your claim. And that is a much more certain outcome for you. You are going to sell your claim for a certain price to a buyer. You're going to go to your credit committee and say, this is the deal that we've got on the table. But there's very little risk in that. You're going to sell, and that's the money they're going to give you. Of course, it may turn out later that you could have got more for your claim, but at least you've got certainty around what you're doing. And I suggest that this has dramatically reduced the importance of collective action problems. In other words, it makes it much less likely that you will be pushing for a sale transaction with all of the risks that that attracts. Much more likely that you'll sell in the market. But the problem that now becomes much more salient is the holdout problem. The problem that parties who buy in will then hold out against the deal, not because they wish to sell the assets, but because they want a better deal or a side deal. And so you get parties buying in on strategies to hold out against the deal to get a bit more, get a tip, get a bit extra. And so I argue that we should worry less about collective action and much more about holdout. And then I think the rest follows. The rise of secured credit, so these structures have a much more significant volume of secured debt than would have been true for large corporates back in the 1980s. But I argue that most of these secured creditors have got incentives to promote the corporate reorganization. If you don't like the corporate reorganization, but one is in prospect, you are most likely to sell someone who does support the reorganization. And most distressed debt traders need the reorganization to be in prospect. Even if you are buying in, not because you're hoping that there will be a debt for equity swap and you will get shares, and then you'll be able to hold the company for 5 to 7 years and then sell it, which is a significant strategy for many distressed debt players. You will know that as the loan-to-own strategy. So it's effectively a private equity type strategy, but you buy in at a low value, you hold the company for 5 to 7 years, and then you either list it or sell it. Obviously, then you need there to be a reorganization. You need the debt for equity swap to happen. But even if your strategy is different, even if you are just buying in because you hope the trading price of the debt will go up, so that's probably the most simple strategy for a distressed debt trader. I buy in now because the debt is trading at 30 cents in the dollar, but I'm going to sell when that trading price improves. In general, the trading price will improve as it becomes more likely that the company will be rescued. So again, what you really want is the reorganization to become more likely so that the trading price goes up, so that you can bank that profit. And so I argue that there is much less risk of a bias towards selling the assets in this complex modern environment, much more likely that you will want the reorganization transaction. And so I argue that the role of the debtor in possession has fundamentally changed. It's much more about signaling this is business as usual. There is going to be a reorganization here, and much less about the debtor somehow trying to tilt the outcome of the case more towards a reorganization. And then I'm going to wrap these last points up quite quickly with an eye on the time. I look at the fall of the lifetime manager. This is one of the chapters I enjoyed writing the most, actually. The very different relationship that we have with our jobs, probably not true of academics, actually, but for many managers in the corporate world, the very different relationship they have with their job, the much greater chance that you won't spend the whole of your career with a single firm. In fact, it's highly unlikely that you will. And so I argue that you are much more likely to think about your investors and the performance of the investment, and that actually has changed the incentives for managers quite substantially from this idea that the reorganization will preserve their job. And the fall of the gentleman banker. So the fundamentally different ways that modern financial actors think about what they are doing. And the argument here is that they are not particularly scared of litigation. In fact, buying into a case in order to be able to pursue a litigation strategy is now extremely common in Chapter 11. So rather than litigation being a disincentive to forced bargaining, actually, if you think you can litigate and win or use it to create pressure, you are much more likely to take that risk as a modern financial actor, or at least that's the argument in the book. And then I look at the implications of these very complex mechanisms for that, using Hart and Moore's work from 2008, so their contracts as reference points work, which again, I can't do justice to today. Read the book. And so reducing opportunities for litigation. And then finally, the fall of the honest broker. So the fact that actually there isn't really a party that sits in the middle of these deals anymore. And that argument actually is quite sui generis, and I make some very specific claims around insider trading. The other 5 points really run through the whole of the book and the concepts. The last one stands somewhat on its own. So I've left myself with 2 minutes and an awful lot of slides, but I'm just going to look at a couple of them and then show you, and we can look at some more depending on the appetite for questions. But first of all, I map these concepts, these new concepts, which I say have emerged, so either reformulated concepts or new concepts. I then map them onto practice as we see it in both the US and the UK. And I argue that we can see in emerging practice a concern for these new conceptual challenges. So the rise of the exchange offer in the US, where you exchange bonds for bonds with different terms, as a method of deleveraging, that reduces transaction costs. It has very particular mechanics to contain holdout threats, and crucially avoids the litigation over valuation, which is fundamental in Chapter 11. Connected party Section 363 sales, which we may have a chance to talk about in Q&A. The really salient point here is that these assume an auction, so they assume a sale. So the valuation which is in play is current market price in prevailing market conditions. And I argue that that is more straightforward than the litigation mechanism in Chapter 11, and therefore avoids some of the litigation risks that we see in 11. Pre-packaged plans, so a couple of big Wall Street firms particularly pushing these. So you line your Chapter 11 deal up, before you go to court. Then you go to court and you ask the court to move very rapidly for confirmation of the plan. Several now within 24 hours, and a new record was set a couple of weeks ago, and I can't remember how fast it was, but it was fast. And of course, what you're trying to do there is reduce transaction costs, but also signal business as usual. By the time you announce you're going to 11, you also announce that you've got a deal. So there's no destabilizing consequence of going into the process. And then finally, contractual control rights. So increasing concern for allocating control rights in the contracts to the parties. Again, this reduces transaction costs. It contains holdout threats if you're able to point to contracts and say, no, look, we've got the control rights here. And I argue that crucially, it plays a role in avoiding the liquidating bias because you know you can use those control rights to promote the reorganization transaction. But then I argue that in England, we've taken this even further. So I look at the scheme plus the pre-packaged administration, and several elements of the scheme which reduce holdout problems and litigation risk. Similarly, the new Part 26A restructuring plan, crucially the role of the relevant alternative, and I don't know whether any of you have studied this yet, maybe we can talk about that, but the role of the relevant alternative in containing litigation risk. And our absolutely ferocious attachment to contractual control rights. So if you're doing finance courses, you may have looked at the Loan Market Association documentation. In the UK, the intercreditor agreement is pretty sophisticated. It will allocate significant control rights in distress to the senior creditors, and the court will generally uphold those. And so we see this focus on using control rights in the contracts to promote the reorganization, reduce the holdout threat, reduce litigation risk, reduce transaction costs. And similar things with lock-up agreements and rights and interests, which I can come back to if there's the appetite to do so. So, in short, the argument is that theory and practice actually ought to merge here, at least in these cases which are restricted to large financial creditors. So when we use an economic lens, we typically think that we are interfering in order to solve some sort of bargaining failure. And this is a fairly broad idea of the economic approach, but what we're doing is we're solving the bargaining failure. So corporate reorganization law is coming in to solve the collective action problem that would otherwise follow. In our new example, it's coming in to solve the holdout problems that would otherwise follow, the litigation risk and so on. But what it wants to do is mimic the results the market would have produced if bargaining had been possible, and it to reduce transaction costs. And that's quite different from a progressive scholar. What a progressive scholar wants to do is look after weakly adjusting creditors quite deliberately. So trade creditors, employees, the community, and so on. And yet I argue that in these cases limited to large financial creditors, the progressive scholars ought to be able to coalesce around the same ideas of reducing the holdout threat, reducing transaction costs and so on, because they should want this deal to happen. They should want the financial liabilities to be restructured as rapidly as possible, because if you can do that, you can prevent the distress from spreading into the operations. And the problem for the constituency they are concerned with comes if the problem stops being a problem in paying your financial liabilities and becomes a problem in your operations. So a good example there are the news reports around Toys R Us. And these are entirely anecdotal news reports. But one of the suggestions of the problems that Toys R Us faced, Toys R Us, massive toy retailer, it had big warehouses out of town. One of the suggestions was that the problem it faced was that it had so much debt, it had to divert all of its cash to meeting its debt service obligations. The more it did that, the less it had to invest in the business. So the shelves become quite untidy, you don't sweep up, you can't build nice cafes and so on. And yet its only future as a business was as a destination. So in order for that business to survive against online retailers, What you want is you want families to decide that on a Sunday we're going to have a day out to Toys R Us. And of course, while you're there, Felix will know you can come under extraordinary pressure to buy toys. And the hope is that you will then concede to the pressure to buy the toys. But if nobody goes, if there's no footfall, then that business model isn't going to work. So what you need to do is deleverage the financial liabilities in order to free up cash, in order to invest in the business, in order to drive the model. And in the book, I argue that a progressive scholar should be as focused on that as a scholar using an economic lens. And where it has gone wrong, in a sense, or where some of the debate goes wrong, is when we forget that it matters who the unsecured creditor is. We may feel very differently if the unsecured creditor is a strongly adjusting, fully informed hedge fund, and so on, than we do if it is a small trade supplier with a serious problem of asymmetry of information. So I have a lot more slides, but what I'm going to do is just pause there for a moment and see if there are any questions. If there aren't any questions, we can plow on. But yes.
Sarah, thanks a lot for the presentation thus far. Perhaps there will be more slides to see. I just should say that my children, which you alluded to, are also pretty good in ordering on Amazon. I'm afraid of the day when I'll come home and there's a big bouncy castle waiting for me in front of my door. Perhaps, Sarah, if it's okay for you, perhaps we could take some questions.
Yeah, absolutely. Yes, this is a good place to pause, and it's sort of a rather freestanding part of the presentation, so absolutely.
If that's okay for you.
Yeah, of course.
So then, just to emphasize, as always, that the discussion is not recorded. So we'll make Sarah's presentation available online. Thank you very much, Sarah, for doing that. But this discussion is not recorded also, so it's a safe space to ask questions. So perhaps there may be questions, to clarify, to explain things more. So please do ask. I've got some comments and questions, but you're always first. So just to ask, are there any questions, which may well be questions to ask for clarification?
Yeah, absolutely.
To expand. Yes, please.
Hi, I just want to clarify, if I understand correctly, so are you more inclined or more in favor of the economic lens compared to the progressive lens?
So I sit on the fence in the book because I argue that that's not really my purpose. So this is, I think, and this is a really astute question, actually, and it's been one of the most common questions about the book, because I don't take a position. What I argue is that we make mistakes if we become very entrenched in our own camps, and we don't start by thinking about what our dominant theoretical concern is when we look at the law. And so what I want to do is show that the argument in the book is whether you're using an economic lens or a progressive lens, whichever of these you think is normatively justifiable. And actually, ultimately, I'm not entirely sure you can ever really conclusively answer that question one way or the other. Whether you think that the chilling effects of what happens in insolvency motivate a particular economic view, or whether you believe that ultimately we have to make difficult distributional choices and we need to look after weakly adjusting creditors. I sort of start from the position that right-thinking people can disagree about those two positions. And I don't make a call on it in the book. What I argue is that it doesn't matter which of those lenses you're using. When we're looking at modern reorganizations, certainly that are limited to the financial liabilities, whichever of those lenses you're looking through, you ought to come to the same place. You want to reduce transaction costs, you want to reduce holdout, and so on. And suppose what I'm also saying is that some of these ideas that have become very associated with one theoretical approach or another actually are often relevant to both. The idea that transaction cost theory is only relevant through an economic lens, I argue is not right. Transaction costs matter for a progressive scholar too. So that's a terrible ducking of the question. The more general personal answer is I think it depends. So sometimes I am much more focused on an economic view, but in other types of reorganization cases, I'm much more sympathetic to something that I think would be more accurately described as a progressive view. So I am a bit of a chameleon, depending on the type of case that is before me. In the literature, I always seem to be footnoted as law and economics, but actually I think my position's a bit more nuanced than that. It isn't really what the book tries to do, though. It's an extraordinarily astute question.
This roundtable, we look at the issue of micro and small businesses restructurings and insolvency. I think an issue that is quite hot at the moment on various levels. We've got great institutions participating. In particular, we've got speakers from the World Bank, OECD, UNIDROIT, and great academics and practitioners speaking. So do sign up if you haven't done so already. Thanks a lot, Sarah. This was really fantastic. It was such a pleasure. You mentioned before coming up that this would be a wild new event because we can meet again after having been in lockdown. So it was so great to have you here. Thank you for coming up. Thank you for participating, for joining, and let's give a round of applause to Sarah to send her home. Thank you. Okay, you know what, I will delete them here again, right,
Yeah,
so that,
yeah.
that they're gone.
That's fine. Yeah.
And then I'll just go to...
I think you should do
You'll do that.
I was going to, but
Okay, no, I'll leave it.
you've done it already.
Thanks so much.
No worries, thank you.
No, we could go over to you.
Yeah.
Yeah.
Okay.
Great. Thank you.